All right, good morning. Can you all hear me?
Yes, Your Honor.
All right, good morning. Welcome to this session of the 5th District Court of Appeal. I'll just remind you guys that this is live and also recorded on YouTube. I'm Jamie Grosshands. On the panel today are Judge Harris and Judge Traver. Can both attorneys see the clock?
Yes, Your Honor.
Yes, Your Honor.
Okay. All right, we'll reserve 5 minutes for appellate's rebuttal. If you'd like an additional period of time, just let me know and we will adjust the clock. We're going to go forward then with 19-2839, which is Security First Insurance Company versus Nanette Phillips. Counsel, you may proceed.
May it please the court. I am David Pascuzzi. I represent Security First Insurance Company. They are the appellant. We are before the court on an appeal from an order dismissing appellant's declaratory judgment action with prejudice. In the lower court, Security First filed an action seeking to establish that there was no coverage for a catastrophic ground cover collapse claim that was reported to it. The evidence obtained by Security First suggested that the loss predated the policy and therefore there would be no coverage. The trial court ruled that Security First could raise this issue only by way of affirmative defense and dismissed the action. As a preliminary issue that I wanted to raise, the declaratory judgment statutes permit parties to file an action before there is an actual liability, and it's under 86.051. And what it states, any in pertinent part, any declaratory judgment rendered pursuant to this chapter may be rendered by way of anticipation with respect to any act not yet done or any event which has not yet happened. And in such case, the judgment shall have the same binding effect with respect to that future act or event and the rights or liability to arise therefrom, as if that act or event had already been done or had already happened before the judgment was rendered. And then also in the briefs we cite, we rely on the Jackson case. And so this idea that we were somehow premature in filing the action, I think, is contrary to the statutes, as well as this idea that an insurer can only raise a lack of coverage by way of affirmative defense. There's nothing in the Declaratory Judgment Act that prohibits an insurer from seeking the remedies that we sought. There's talk in the some of the case law regarding some of the older cases that talk about discretion and some sort of gatekeeper function. That wasn't an issue that I think the judge raised, but in any event, those deal with an issue as to whether or not there's a bona fide need. So if like a plaintiff sues for breach of contract and declaratory judgment, the court in that instance would have some type of discretion to forego or dismiss the Declaratory Judgment Act count, if you will, based on the duplicativeness of the count or theories with the breach of contract action. An insurer that was in our position at the time didn't have that remedy available other than to file a declaratory judgment action. There's nothing, again, there's no basis to require that we be sued first or that we not be permitted to file a declaratory judgment action to establish lack of coverage. It's a rudimentary, basic way that insurers use all the time to establish whether or not there is coverage for a claim that is pending. So it wasn't an issue where there wasn't a bona fide need. The claim is pending, the parties are adverse. I don't think there's any question that this is a real claim as opposed to some type of, yes.
There seemed to be some disagreement in the briefs, or at least discussion about what our standard of review is. What is your position on what our standard of review is in this case?
The fifth district cases that we cite in our brief suggest that it is an abuse of discretion, but the conflict that's apparent that the second DCA mentions in Rabaya really isn't material in our situation, because if you go by the abuse of discretion standard, ultimately those courts determined that the issue was one of whether or not we stated a cause of action. The court was determined to have abused its discretion where it dismisses an action where the complaint states a cause of action. So it's really not a distinction, I think, that is significant in terms of whether it's de novo versus an abuse of discretion as it relates to whether we stated a cause of action. Fundamentally, the issue is whether we're entitled to a declaration. We don't have to be right about the facts. We just have to be entitled to a declaration. Once there's a justiciable issue, that is a controversy between the insured and the insurer, as there was in this case, where they're making a claim and there's a belief on the part of the insurer that it may not be covered, there was a sufficient controversy for the insurer to file a suit seeking to establish that it wasn't covered. The other aspect of discretion was what I mentioned before, where there's some older cases that suggest there's a discretion as a gatekeeper function. And this is talked about a little bit in Rabaya. I think it's also talked about in the concurring opinion that's cited by the appellee in their brief in the McIntosh case. And essentially, again, that goes with as to whether or not it's duplicative. So again, in the event that a plaintiff sues for breach of contract and a couple of other causes of action, and they're duplicative of a declaratory judgment action, the court has discretion to reject or dismiss the, I guess, a judicial restraint, if you will, on the Declaratory Judgment Act part of it, or the count. We don't have those facts in our case. That's not our case. Security First wasn't able to sue the insured for breach of contract. We only have the one count for declaratory judgment seeking to establish that based on the facts that were provided to us, this loss was not covered. There's an effort, if you will, to try to establish a judicially created exception to the statutes, which I don't believe is proper, that somehow an insurer can only seek declaratory judgment action for lack of coverage if it's a liability question under a liability policy or a lack of cooperation. Again, there's nothing in the statutes that would support some judicially created exception. And there should be a construction that's limited to the statutes themselves. So if there are no other questions currently, I'll reserve the rest of my time. I did kind of blow through some issues, but I don't want to belabor the point if the court doesn't have questions at this time. And so I'll reserve the rest of my time.
All right, we'll reserve that time. Mr. Reeder, you may proceed.
Thank you, Your Honor, and may it please the court. You know, I was preparing yesterday, and I was scripting out what I was going to say. It dawned on me that this isn't that kind of case. It's not really necessary in this case. The reality is this appeal was moot when it was filed. The lower court entered its order dismissing this action on August 19, 2019. The appellee in this case filed their complaint for breach of contract that same day, 8/19/19. Now, I know that complaint is not a part of this record on appeal, but it is because the appellant filed a motion to dismiss that action in this court, or to stay that action in this court and attach that complaint as an exhibit. So that's certainly within this court's record. So that complaint was filed on 8/19/19. The appellant has now answered and asserted pre-existing condition as an affirmative defense. and we're set for trial in December. So the issue that's on appeal right now is moot, and was moot at the time of the filing. So really, the whole issue shouldn't even, it's a waste of judicial resources at this time to even continue this appeal. That being said, and we can go through the cases ad nauseum if we want, there's only 3 cases that the appellant relied upon. And that was the Tyndall case, the Conde case, which is this court's case, and the Higgins case.
Mr. Reeder,
Yes,
I'll
ma'am.
ask you a question. Can you, I believe in your brief, you argued that Florida courts have restricted this type of action in insurance cases. What is your best case for that proposition, that it's been restricted in some way by the courts?
Well, I think all of them, quite frankly, Your Honor. I think the 3 cases cited, and I was about to get into that, there's a common thread that goes through all these cases. We don't have to go through each one. We see this thread, and it's prejudice. So if we look at the Tyndall case, which is a PIP case, and the insurer is actively paying out PIP benefits, and the insured fails to cooperate, says, I'm not going to cooperate anymore. The insurance company comes in and says, wait a minute, we're paying out these benefits. We're never going to get that money back. And we shouldn't have to pay that out. So we should have a deck action to be able to do that. And the courts, okay, initially the trial court said no. And the appellate court said, no, I think you should be able to do that. So we have that prejudice thread. If we go to Conde, which is this court's case, there was an intentional shooting, and it was pled as an intentional shooting. And so the insurer came in and said, wait a minute, they've pled themselves out of coverage. We are actively paying for a defense. So this is money, I assure you, the insurance defense attorneys are not going to give us back. We're losing that money. So there's that prejudice element. In Higgins, exact same thing. We had Mr. Higgins brutally beat a woman in his house, and it was pled as an intentional assault. And the insurance carrier came in and said, wait a minute, we're defending this guy. We're paying these lawyers. We may have to indemnify him. Let's do a deck action first. And in the Higgins case, that was really kind of a contested situation with the court. We had 4 of the majority, we had 2 dissent, and 1 judge recused herself. So it wasn't clear cut. And even in that respect, and we can go to the Higgins case, which I'm going to cite for the court. It's 894 Southern 2nd 5, it's 2004. The question that was originally asked of the court by the 4th DCA, and this is found on page 9 of the decision. The question, the certified question was, may the insurer pursue a declaratory action in order to have declared its obligation under an unambiguous policy, even if the court must determine the existence or non-existence of a fact in order to determine the insurer's responsibility? Well, that's a pretty broad question. This is how the Supreme Court rephrased that question. And it's literally the next line after the question. This question presents the issue of whether Chapter 86, Florida Statutes 2003, Florida's declaratory judgment statute, authorizes declaratory judgments as to insurance policy obligations to defend and coverage for indemnity when it is necessary to decide issues of fact in order to determine the declaratory judgment. So they narrowed that question down specifically to issues of defense and indemnity. And we see the same thing in Conde. This court's case is exactly the same. Now, in the Higgins case, which is the Supreme Court case, we noticed that, and you asked about the standard of review, Your Honor, and it is abuse of discretion. In fact, in the Palumbo case, which was this court's case, the standard of review was specifically when dismissing a count in a complaint seeking declaratory judgment, the trial court's ruling is accorded great deference on appellate review. And that's Palumbo v. Moore, 777 Southern 2nd, 1177. That's this court's case out of 2001. The standard of review as to dismissal of a declaratory relief claim is whether the trial court abused its discretion. And that's consistent with the Higgins case. Because if we go to the Higgins case, and I'm looking at page 17 of the case, the Supreme Court of Florida says, we conclude that there's too infinite a variety of circumstances for there to be a rule applicable in all cases. And we're talking about the various factors that a trial court should examine when determining whether a deck action is appropriate. For that reason, we continue to hold that the timing determination, whether or not it's premature or appropriate at that time, is within the discretion of the trial court, weighing the factors we have outlined, as well as the factors of the particular case. So what do we have? Well, in this case, we have some factors, and they're found within all of these cases. The first one is prejudice, and I discussed that. In each of the cases cited, and in fact, in all of the cases in Florida in which a deck action is appropriate on behalf of an insurer against an insured, there must be some kind of prejudice. There's not a single reported case in Florida where that doesn't exist. So we've got that. In this case, there is no prejudice. My client made an insurance claim, paid all of her premiums. She had a catastrophic loss to her home. She made a claim, and instead of the insurer, the appellant in this case, complying with Florida Statute 627.70131 sub 5A, which requires a claims decision, it's not discretionary. It says they shall make a claims decision or pay the claim within 90 days. We're 2.5 years. We still haven't gotten a claims decision. What we got was a lawsuit filed against them. So in that situation, there is no prejudice right now. They never even made a claims decision. And the court was on that, because when we look at the trial transcript, the court, and I'm looking at page 121 of the record, starting on line 3, the court says, and next, you haven't even denied their claim yet. And the appellant says, well, that's correct. And the court goes on, says, well, assuming you do, then it's incumbent upon the plaintiff whether they want to pursue it or not. They may just walk away and say, you know what, it's not worth it. I'm going to lose the house in foreclosure. I'm going to go my merry way. No harm, no foul. Or they may say, I'm going to file suit, and then you raise your affirmative defense, because that's what this is. It's an affirmative defense.
Mr. Reeder, how would you distinguish this case from the Heritage Property and Casualty Insurance Company case out of the third? It was from 2017.
Your Honor, that wasn't cited in my brief, Your Honor. I didn't have that as part of my argument.
Okay.
Yeah, so I'm not familiar with that case, Your Honor. What I can tell you is that in the Higgins case, which is the Supreme Court case, that's really the seminal case in Florida in regarding deck actions. The other issue, and in the Higgins case, the Supreme Court actually cites to the Vanguard case, which is this court's case, and specifically states, and again, I'm on page, looks like page 14. It's right at the top of page 14. The Supreme Court cites to Vanguard, and Vanguard is Vanguard Insurance Company versus Townsend, 544 Southern 2nd, 1153. That's a 1989 case here out of the 5th. And they quote the Vanguard case and says, one of the reasons, this court's reason for expanding the deck action, even to include defense and indemnity situations, one of the reasons for permitting parties to have their rights and obligations under contract determined is to avoid protracted and unnecessary litigation. Well, what the appellant's position is requesting is the complete opposite of that. It encourages protracted and unnecessary litigation. And again, the trial court was all over that. In fact, if you look to page 122 of the record, line 18, the trial court says, it just seems like, to me, we're going to start going down a road where we could just have tons of litigation. So the various factors that the Supreme Court brought up, stating that these are factors the trial court should examine, the trial court did, in fact, examine all of these. The next one was flipping the case to where really the insurance company is driving the case, and they're in control of the pleadings, the evidence, things of that nature. In fact,
Mr. Reeder, let me bring you back. I think Judge Grosshand's question was pretty fair about the Heritage Property case, even though you didn't cite it. It's certainly cited in the appellant's initial brief, so I think it's fair for us to ask you about it.
Sure. Yeah.
Very factually similar to what we've got here. And in that case, the court, citing Higgins, said that it's appropriate to do exactly what the insurance company did in this case, and it's get the court to make a factual decision about a coverage issue. In that case, it's whether the appraiser was competent and impartial. So how is that case not, at least, if not controlling, very persuasive on what we do in this case?
Well, Your Honor, and again, I apologize. I don't have that case in front of me, and I don't recall all the facts of that case as I sit here. What I can say is that the factors that were set forth in the Higgins case, and maybe that case might be somewhat persuasive, but certainly Higgins controls. And the Higgins case lays out certain factors and states that it's the trial court's discretion in weighing these factors. And
Well,
certainly,
you say in your brief that Higgins was discussed almost exclusively the prejudice involved. Where is the prejudice discussion in Higgins? How is that almost exclusively what the court discussed?
well, Your Honor, in Higgins, and it may not have been exclusively prejudice, but certainly the court goes through many of these factors, and then towards the end talks about how there are to infinity a variety of factors. The implication throughout the case is that there is in fact prejudice. The whole case is based on the fact that there's this defense and indemnity obligation of the insurer that they're having to pay before they get this deck action resolved. And in fact, that again is the common thread that we see in all of these cases, that there's this prejudice issue where the insurer's having to either pay out money, defend the case, things of that nature. That doesn't exist in our case at all. In fact, one of the other factors is, as I was talking about, was the fact that the court is concerned about flipping the litigation, allowing the insurance company to really control the litigation. And what we see is even Judge Quince in her dissent in the Higgins case, if we go to page 20, she warns us of this 16 years ago, where she says to hold otherwise is to allow the defendant to have control over the litigation brought by the plaintiff. Again, the trial court talked about this in great detail. In fact, if we go to page 121 of the record, starting on line 22, the court says, I think what we're doing here is we're trying a sinkhole case and we're calling it a declaratory judgment. Because in this, if I let this go forward, then the plaintiff has to prove the facts that the damage came after they brought the policy. So again, that's another one of these factors that the court considered. The court didn't just say, no, you can't do it. The court went through each of these factors. Another one of the factors the court went through was the fact that allowing this, and if this court reverses, it is effectively putting its rubber stamp on the fact that it's okay for an insurer to willfully violate Florida law. Because what we have here is security first, failure to comply with the statute requiring a claims decision in 90 days. Instead, they filed a deck action. We still don't have a claims decision. To this day, we have no claims decision. Certainly, that's a requirement under Florida law. And finally, ultimately, the court said there's no dispute at this point. And there really isn't a dispute. I mean, my client made a claim and she never received a response. She got a lawsuit. The fact that the lawsuit was filed doesn't in and of itself create a conflict. Otherwise, we wouldn't have the need for the element that there be a conflict and one that needs to be justicially resolved. Finally, and as I started out, the whole appeal is moot at this point. We have a trial date in December. The affirmative defense of pre-existing condition has been raised, and we're moving forward to that. So with that, if there are no further questions, thank you for your time.
Thank you. All right, counsel, you have, I think you have about 12 minutes left, if I remember correctly, yes. And could you start by addressing Mr. Reeder's contention that the case is moot?
Yes, Your Honor. There's a bunch of reasons why this case is not moot. First of all, that argument is beyond the brief, so I don't think it's proper to even raise it during oral argument. But in any event, the reason why it's not moot is the trial court ruled essentially that we couldn't do a counterclaim for a deck action, that basically an insurer can never sue for declaratory judgment, whether it's as a primary claim or as a counterclaim or declaratory judgment, that there was no coverage based on a on evidence that suggests a pre-existing condition. So that is something that we substantively have been deprived of the ability to file a declaratory judgment action. So that's still ripe. That's not mooted at all. The other side filed a lawsuit that we had to respond to, but, and again, this is all beyond the record. So it's a little difficult to get into, but there was a presentation of a request for an agreement to try to permit a DEC action, or these issues would not be barred from being litigated in the second case, and there was never any concession. So the case is still ripe in that sense. Number two, it's also ripe because there's a pending claim for attorney's fees. They've filed a motion seeking attorney's fees. So that's the second reason why this is not a moot determination. And third, and this is kind of segues into sort of the second point I wanted to make. Really, it sounds contradictory, right? Insurer, you're not allowed to file a DEC action while there's a claim pending, but meanwhile, we are going to hold you to this 90-day clock that's running, and we're going to hold you to the claims handling statutes and all the bad outcomes that can happen if you don't follow or meet those issues. So there's a fundamental conflict within their own argument that somehow we can't file a DEC action while that time frame, that claims handling deadlines are running. And I think that's not the law. An insurer can sue for a declaratory judgment to seek that it is immune from liability on a pending claim. We've alleged sufficient facts to show that there is a present need for that declaration. Just because they said, oh, you can't file a DEC action, and then as soon as that one's dismissed, I'm now going to sue you. So it wasn't right before, but now it's right. I just think that sounds like gamesmanship and completely contradictory and unfair as how this played out or should have played out. If anything, it almost implies that there might be some concession of error, which if that's the case, then again, we should have been permitted to file our lawsuit. They would have had to have answered with a counterclaim. And we as the plaintiff could dictate the factual issues to which we would then be entitled to some admission or a denial. As a defendant, you don't get any of those things. You don't get an admission or a denial as to your affirmative defenses. But as a plaintiff, you do. And I think that's another segue into the point that was trying to be made, that there was some suggestion that the roles can't be reversed, that an insurance company can't be the plaintiff. It happens all the time in coverage cases in which they do file a DEC action. But I think the point that Justice Quince was making was in a very specific context at a time back in, when it was filed decades ago, in which there was a belief that there was unfairness on if there was a bar fight, for example, under a CGL policy, which everybody knows should be excluded, but the four corners then limits the victim, with the ability to raise that it's a negligence count, that the insurance company's hands were tied. And that's the defendant they're talking about, that the defendant couldn't challenge the veracity of whether or not this bar fight was really a bar fight versus some negligent issue. And that's where Higgins kind of emanated from, that in addition to a court being able to determine questions of law in a declaratory judgment action, they can also determine factual issues can be raised through the vehicle of a declaratory judgment action. And at the time, it was an important distinction. Since that time, there's been no change in the law to suggest that that there is some prejudice test established in Higgins, or that insurers are only limited to filing DEC actions in liability policies, or some limitation that of a lack of cooperation. The statute is liberally construed. There's no judicially created exceptions to the statute that prohibit an insurer from seeking a bona fide, a declaratory judgment to resolve a bona fide dispute between an insured and insurer as to whether or not a claim is covered. That's a fundamental basis for why the declaratory judgment action statutes exist, to resolve this type of need for resolution of a controversy that's pending between the parties. Those are all the points that I wanted to make. So in conclusion, what we request is that the court reverse the judgment and with instructions to deny the motion to dismiss, and that would be the outcome that we're seeking. So if there's no more questions, thank you.
Thank you, counsel. Thank you both. And this
Thanks,
will end
counsel.
our session. Thank you again.